I want to welcome you to the show. This is definitely an honor. I appreciate the work that you're doing. And I'm sure the viewers will find the information very empowering and also, helpful.
Well, thank you. I hope it is helpful. And I think the things that have happened to me are pertinent to everybody.
Yes, indeed. Yes, indeed. For the viewers who may not recognize you, let them know what your name is and definitely what do you do?
Okay, my name is Bob Grundstein. I'm an attorney. I have Cleveland roots. My father was a professor of law and public policy at Case Western Reserve, and we lived in Cleveland Heights. So your viewers may want to know, why is someone, in Vermont talking about Ohio? So that's the reason. I have Cleveland roots, and a lot of the stuff that happened in my book, Bad Minds, High Places, it all started in Cleveland. I would have had no trouble had I not litigated in Cleveland from the start.
Okay. I can definitely relate. I'm from Cleveland, Ohio as well. I lived in Bedford. I went to Bedford High School. I lived
No,
in
you live really Bedford. Oh my God, that's where everything bad started for me.
Right. But I lived in Cleveland Heights. I lived all over, so I could definitely attest to some of the things you're saying for sure. Now I can ask you this: the book. If you could talk about what was the inspiration behind the book.
Well, the inspiration for the book was, the catastrophes that I endured that I never expected to happen. I mean, you go through this personal experience. I mean, everybody has personal experiences, and they're always, important to the person. We're all the same. But this, my experiences with the legal system were very surprising, because we're all taught that the legal system, we're taught to trust it, and that, the people in the legal system would rather do anything other than fail their ethical duties. And I found it's absolutely the opposite, especially in jurisdictions where in states where the judges are elected. The judges and the attorneys are an interest group who will lie and do all sorts of illegal things to protect their income and professional status. And they also organize. The judges talk to each other. So a lot of these outrageous things that happen will be covered up because the judges talk to each other, and this cooperation will extend from the lowest municipal court to the local federal court, which will, prevent review of violations of due process at the state level. So that's sort of like the conceptual thing. I'm sure you want to know some of the individual events and specific events that happened to me.
Yeah, definitely. And just to reiterate, you actually share a perspective from the inside. A lot of the viewers may be on the outside. They don't have the experience. You went to college, you went to school. If you could speak about that a little bit.
Well, yeah, I was born in Detroit. I come from a family of academics. My dad was, taught at Wayne State. And then we moved to Cleveland eventually, where Dad taught at Case Western Reserve. So it was, very protected, white, middle-class professional family. I never had a lot of money, but we had good thinking. And my father was, had always had a very strong code of ethics. So that was good. Then I went back to University of Michigan from Ohio. And then eventually came back to Ohio to go to Cleveland State for law school, because I couldn't afford anywhere else. I had to put myself through. So I went to law school at Cleveland State. And one of my classmates was actually Frank Celebrezzi, who's on the 8th District Appellate Court right in Cleveland. So that's a little about me.
Okay. Now, how did you actually, get the attention of the Cleveland legal system?
Oh, God. Okay. Well, I'll tell you two events that got me, that sort of made me a person of interest in the Cleveland legal system. And then I'll come back to them with respect to an event that happened 5 years later. My dad died in 2000. I moved back to Cleveland from Los Angeles to take care of my parents as they got into advanced age because they needed someone around all the time. That was me. So I was there, and I got a condo in Chagrin Falls, and had a piece of property. And my dad died, and for some reason, well, my mother, my dad had some collectibles my mother didn't need, and she consigned them to a fine arts auctioneer, Wolf's Gallery Inc. He sold them for $30,000 and gave my mother nothing. He basically cheated her. It happens in adult life. You're lucky if your mother loves you. Everybody else, you're an object of extraction. So I was outraged. I mean, my mother was a newly created 87-year-old widow, and this guy stole $30,000 from her. So I made an arrangement to have the proceeds, put in my name, and I sued on behalf of my mom. The first case I ever filed in Ohio, ever. And I sued, and the case was dismissed. The judge was Nancy Margaret Russo. It was very nice. She dismissed it on a procedural basis. This was in 2001. I appealed, and it was remanded. I won the appeal, which is unusual because only 15% of people win appeals. And it was remanded back to a judge named Lillian Green. Lillian, this was in 2000. It takes a long time, so it was remanded back to her, in like 2004, 2005. She just didn't want the case. She was notorious for being slow, for not keeping up with her docket, for being lazy. She just didn't want the case. So, when you file a case, you have the complaint, then you have the answer, then you have motion practice. And motion practice is when you do briefs in support of your case. And so I filed my briefs, and it involved a limited liability corporation, which was new at the time, and it was very healthy for the legal system to analyze how they behave. So the fine arts auctioneer was a limited liability company, and I was trying to pierce the corporate veil because they committed fraud, which means you get to the person, you get to the individual, you get to Wolf's assets, and he can't say, well, I'm a corporation, and our liability is limited to the corporate assets, and we've gone bankrupt, so we don't exist anymore. And when fraud happens, you go to the person. So opposing counsel, just out of the blue, he was a local attorney, and he just said, well, let's, on a motion, he said, let's declare Bob, me, vexatious under Ohio's vexatious litigator law, ORC 2323.52. So he made a motion to have me declared vexatious. So I said, well, how can you do that? One, you can't do it on motion. The statute requires a new action with a new complaint, filing, service, summons. Secondly, I haven't done anything wrong. I just won an appeal. There are no Rule 11 motions. Rule 11 motions are when you do something that's, bad in law or fact. There are no 12 motions against me. There are no, sanctions. There's no contempt. I've done nothing wrong. My work is very good. How can you even do this? I thought it was laughable to me. I mean, wow. So Lillian Green, the judge, said, yeah, Bob's vexatious. He can't litigate anymore. I mean, to me, it's not like, okay, this was a revelation. This was a revelation. If you're a local attorney and you can help a judge clear her docket at the expense of someone who doesn't matter, that's me. I didn't matter. I wasn't, a member of the Cleveland bar, the Ohio bar. We can shut him up. We can get rid of him. And nothing bad will happen to us because he's a non-person. So I said, well, okay, you've done this. This is easy. No problem. I'll just appeal. I mean, the statute's very clear on, what you have to do. You cannot declare vexatious, someone vexatious on a motion. It has to be a new complaint, new filing. They had to serve me. You have it's a new, you have new motion practice. You have a trial to see if someone's vexatious, because this basically eliminates you from your First Amendment rights to go to court. You're silenced. You're dead. In addition, once you're vexatious, you can't file anything in any Ohio court without permission of the court that declared you vexatious. I mean, it's incredibly unconstitutional. And even I think the second district in Ohio declared it to be unconstitutional. So anyway, I make an appeal. Say, okay, this is easy. I mean, this is easy. I got my brief in on time. I sent my filing fee, and they have me come in from Vermont for oral arguments in March of 2006. My appeal was made in August of 2005. So I drive in all the way from Vermont, and I see the bank of judges. They're celebrity. There's this one woman named Diane Karpinski. Diane is very smart. She once offered me a job, and I noticed that they had a judge pro tem, the presiding judge, the leading judge. They changed out the judge, and it was a guy named Corrigan. Now the Corrigans run Cleveland. They're a very powerful name in Cleveland. And so Corrigan's the judge pro tem. So I'm sitting there, and he goes, okay, thank you for coming, Bob. You don't get your appeal. And I said, what do you mean? I filed on time. I drove from Vermont. It's 1,500 miles round trip. What do you mean? He goes, sorry, we're not giving you leave to proceed. Go home. So there. So I couldn't believe this was happening. It proves that, one, they're corrupt. Two, Lillian Green called the appellate court, said, help me out, don't embarrass me. And three, the judges cooperate, and they also favor local counsel. This is the nature. Systemically, this is important. Not just, oh, poor Bob. It's just they will do bad things at the expense of what they're supposed to do to maintain the support of their constituent voters. It's a real design defect of places where judges are elected. So that's event one. I'm vexatious in Ohio, and I can't even get into the courts. So event two, which will be important, is when I was coming in from Vermont to do there were hearings from my mom's, for the case I just described, the theft of the document, the theft of the money from my mother's, by the fine arts auctioneer. I drove in, and I was staying with an old girlfriend in Lakewood, and I had a parking violation on Clifton Boulevard, and they towed my car. That's fine. And they found my gun in it, which was fine. I didn't have it properly stored, so that was legitimate. I did wrong, so I went to Lakewood Municipal Court. They fined me. I went home, and that was fine. Improper storage of a firearm, that's fine. So I went in Vermont. You're allowed to, buy a gun without a license, and so I went to buy another gun. I wanted a 9mm in addition to the 22 I had. So I went to the gun store. And the gun store, they do this point of purchase FBI investigation. It's called a NICS test. So they said, well, we can't give you the gun because you don't pass the NICS test. I said, why? And they said, because you have a violation in Lakewood, and we can't tell if it's a felony or a misdemeanor. And you can't have a gun if you're guilty of a felony. So I said, okay, that's fine. And I get it. So I, got a bunch of documents from the Lakewood Municipal Court, including the charging document. And the charging document had me guilty of charged under misdemeanor Lakewood Municipal Court 504 subsection 3. Now, all the cases in Lakewood Municipal Court are misdemeanors. It's a court with only misdemeanor jurisdiction. And all the violations under 503.04 are misdemeanor violations. So in my charging document, they didn't have the subsection So I got the documents from Lakewood Court to prove that I wasn't guilty of a felony. In green ink, I added the subsection C and wrote a letter to the FBI in West Virginia saying, I added the C because the subsection's missing, but it doesn't make a difference because they're all misdemeanors. And the only thing is, is this a misdemeanor and a felony? So the FBI got it and said, oh, yeah, okay, that's fine. Go buy your gun. It's not a felony. So, and this happened in, 2002. So 2002. So we have two events. One, I'm declared vexatious and they wouldn't give me an appeal and I have no access to courts anymore. And two, there's this document, a copy of a record from Lakewood Court, Municipal Court, in which I added a subsection C in green ink. It wasn't fraud. I didn't change an original. I didn't say anything untrue and sent it to the FBI. So there are these two events. So let's go up to 2007. I mean, you need to ask me anything, Taye? I hope I'm not talking too much.
No, definitely. I appreciate you taking the time to break it down. Okay. Like I say, I'm from Cleveland, so I can relate. It's definitely a history of corruption and police brutality and things like that. I wrote a book about the civil rights and Black Power movement of the 1960s and 70s, and the name Corrigan is definitely a name that I'm familiar with. A lot of the struggles that and legal battles that the activists they had to go in that courtroom.
Oh yeah, I'm sure this is all familiar to you. I was sure to you they say, yeah, we've been looking at this a long time, Bob.
yeah, definitely. But
what's the name of tell me the name of your book.
Okay, the name of my book is called The Afro Set.
Oh, good. I'm gonna have to get a copy of that.
Oh yeah, check it out. It's definitely a lot of history. Like I say, it goes into detail about the civil rights and the Black Power movement. We had the Huff riots, we had the Glenville riots, and it talks about a lot of that. The fight for integration and civil rights and stuff like that.
Oh no, that's interesting. I got to get that.
Yeah, definitely. Now I wanted to ask you about the 2007 indictment.
Right now things get really hairy. So as I told you, I had a condominium in Chagrin Falls that I bought. And it turns out that the owners association, the management company, did an assessment for a new roof, and they charged $150,000. I know something about construction. I do minor real estate development in Vermont. And I said, that's high. So I called the contractor and I said, why is this $150,000 for a new roof? I happen to know it should be much less. And he goes, no. And the contractor said, we did not charge your condominium $150,000. We charged them $75,000. Someone is lying to you. I said, well, thank you for your honesty. Can you give me documents for this? And he goes, yes. So Chagrin Falls is in Bedford Municipal Court jurisdiction. So I sued the Condominium Owners Association, the management company, for fraud. And I wanted our money back for everybody. I was suing for everybody. I was an attorney, so, I could do the work for free. It's a stupendous amount of work, but I was doing a service not just for me, but for the whole condo. And it's responsible. You don't want to have, the condominiums have 150 people to the large development. A lot of people being, cheated. You don't want someone who's going to, you don't want a management company in the area who's going to be doing large scale fraud on the citizens. So I got Peter Junkin at the Bedford Municipal Court. So Junkin, had me come in from Vermont. My condo was rented, so I was still living in Vermont. So my Cleveland condo was rented. The Chagrin Falls condo. So I drive in from Vermont for a hearing because the opposing counsel, a very established Chagrin Falls law firm, made a motion to dismiss, which is normal. It's very normal to make a motion to dismiss. You normally don't get them, but it's okay. You just say, maybe we can avoid the whole thing. So I drive in, And there's Junkin. And he says, okay, you're a vexatious litigator. We really shouldn't be hearing this case, but, we'll hear it. And he goes, he didn't know the file. He didn't know any of the facts. He's flipping through it. He finds a sentence he doesn't like and he recites it. And he goes, okay, case dismissed. So I was outraged. I mean, this is insane. He didn't even know the file. He didn't cite any legal criteria. I'm trying to protect, a bunch of people. It's not just me asking for money. I'm, trying to get, return to a community standard. So I was so angry, I wrote an editorial. And I published it. And I called the law director, a guy named Burdick, and I called him and said, listen, I'm going to publish this, and I'm also going to pass it out on the steps of your courthouse, while the court is in session. Because Junkin, he shouldn't be where he is. Turns out also Junkin was later removed from office during the corruption scandal. I don't know if you remember that name, Peter Junkin. Do you remember that name, Taye? Peter Junkin was part of that. He was in Bedford Municipal, which, lost a lot of people. So I go to the, the court, pass out my editorial, and the attorneys are taking it and reading it. And this was in April of 2007. Then I go home, drive back to Vermont. Now, let me tell you a little bit about Bedford to refresh your memory. Bedford Municipal Court was a huge focus of the Cleveland corruption scandals. Huge focus. One of the former law directors and prosecutors, a guy named Tommy Longo, was arrested in Mexico on an international warrant. He was on America's Most Wanted. Remember that old TV show, America's Most Wanted? He was a former law director and prosecutor, Tommy Longo. He was arrested. He was arrested in Mexico on an international warrant. He was guilty of drug charges, weapons charges. He was doing date rapes. He was giving women roofies and then violating them sexually while they were unconscious. And this is the prosecutor who's dealing drugs in Little Italy. This was the law director and prosecutor. Then recently Judge Harold Jacobs, who was a judge at Bedford Municipal Court, was removed for engaging in activities in support of prostitution. There was some local prostitution activities, and he was helping the people who were, really running prostitution and certain buildings containing prostitute activity. Then the second law director, a guy named Ken Schuman, was also removed from office. He's also from Bedford Municipal for, participating in activities in support of prostitution and taking bribes. So then Peter Junkin, who was a judge there, was also removed for he was under heavy FBI investigation. So you have two law directors, two judges, and then a fifth person, Joe O'Malley, who was he could be a prosecutor pro tem for Bedford. They would hire him as they need them. He'd also work for Parma. Joe was put in federal prison for lying to the FBI. So, I mean, if you go to if you aren't a criminal and you go into Bedford court, you're in trouble. You're just not part of the group. So anyway, so in April 2007, I published the editorial and passed it out on in Junkin's at Bedford Municipal Court in the front steps on a very nice day. 6 months later, on Halloween, I'm sitting in my place in Vermont, and the federal police arrive. Not the federal police, the state police, sorry. They say, gee, Bob, we're arresting you. I say, well, really? Why? He goes, we have a felony warrant from Ohio, and we're going to put you in jail and chain you to a bus and extradite you to Ohio. And guys, this is serious. I knew the state police there. I'd helped them with some undercover drug activity. I knew them. And so I said, well, what is this? I didn't do anything. So they showed me that the grand jury had indicted me for a third-degree felony, altering a court document. And they said it happened in 2003. So I looked at it and I put two and two together and said, okay. So meanwhile, I'm handcuffed in a police car, being taken to jail, putting this all together. And so I was released. The prosecutor said the local prosecutor let me out for a little bit. He said they didn't have enough to hold me. But then they rearrested me after Ohio provided more information a couple of weeks later. So there I am. I got to go to Ohio. I'm being extradited. So I look into it, and I look into the file. Every criminal case has a case number. So I looked at my case number, and it said on April 23rd, 2003, Robert Grundstein altered a court document and, did this and that. And so I had ATM receipts to prove that on those dates, and for 6 months before and 6 months after, I was in New Hampshire and Vermont. I wasn't even in Ohio. And the statute under which I was being indicted said you have to, alter an original of the court document, which means you have to be in the clerk's office. Like a lot of attorneys go in, they say, "Can I see the file?" And they change, $100,000 award to 10 cents. Hang on, Ty, my battery's running low for some reason. Okay, I'm plugged in. So sometimes attorneys will go in and they'll, say, okay, it's rare, but it's a kind of felony where, let's say, attorney goes into, "Can I see the file?" And the clerk gives it to him, and he changes a $1 million award to 10 cents, and he scratches it out. That's what the document. That's what the indictment was for. So I didn't do that. And on April 23rd, I wasn't in Ohio. I was in New Hampshire and Vermont doing construction projects. And that date, April 23rd, just also happens to conform to the time, the address on the letter to the FBI, where I sent, a copy of the Lakewood criminal charges against me, where I put on, added in green ink with a letter addressed to the FBI saying, okay, I added this to the court record, but it doesn't matter because I just need to prove it's a misdemeanor. It's not like I'm, changing a felony to a misdemeanor. And then the FBI said, yeah, we see it. No big deal. So then I looked further. The grand jury refused to indict me. I got a no bill. They, Bradford, Peter Junkin and Bill Mason, who was a prosecutor at the time, did all this shitty stuff. And they brought it to the grand jury. The detective, I found out, was a guy named Mackey. And the grand jury in June refused to indict me. I got a no bill. No one gets a no bill. You can indict anybody on anything. Grand jury, a grand jury is you're dead. You're alone. You don't know you're being indicted. You have no, right to an attorney. You can't make a defense, and you're just, very vulnerable. And they always indict you. I got a no bill. No one gets a no bill, and I got one. So in Ohio, according to the case of Freilich versus Ohio Board of Mental Health, you're not allowed to re-present to the grand jury under the same facts once you've had a no bill. And that was me, but they re-presented anyway. And then they for some reason they got an indictment the second time. I don't know why. And under the case of Freilich versus Ohio Board of Mental Health, that's malicious prosecution. So, okay, I'm cooked. This no one's helping me. They're not even doing the law. So I have to go to Ohio. So I called the Ohio bail people and I said, listen, what's my bail going to be? I don't want to be extradited. And the bail bondsman looked at it and he goes, there's something really wrong with this case. He goes, you know what? I'm going to let you go on your own recognizance. You don't have to go on the bus. We're not going to chain you. We're not going to hold you in jail. You don't even have to give us any money. Just promise that you're going to be here for your arraignment. So I drove in from Vermont at the arraignment, and I, I say, okay, I'm not guilty. So what happens after an arraignment is you have pretrial hearing. There's a Rule 12, criminal Rule 12 pretrial hearing where the prosecutor shows you his evidence, you show him your evidence, and you say, okay, do you really want to go to trial? So I also made a motion to dismiss. I had an alibi thing. One, I wasn't in Ohio at the time, and two, I didn't do anything wrong, and three, I got a no bill. I shouldn't be here. So I made a motion to dismiss on those bases, and also a motion to have the criminal Rule 12. I can't remember the Rule 12 or criminal Rule 8, but you get a pretrial hearing conference, and I said, let's schedule that too. So anyway, they refused to have the mandatory pretrial conference. I mean, it's mandatory. You have to have it, or the prosecutor wouldn't do it. So I couldn't avoid, a trial. I said, well, guys, so I made a motion to the judge to enforce the criminal rule, giving me a pretrial hearing, and pretrial conference. The judge, who is Michael Russo, refused to do it. He would not rule on any of my motions. And according to the rules of superintendents for the court, a judge has to rule on a motion within 120 days. So I said, okay, something's really wrong here. So I wouldn't get the pretrial conference, and the judge isn't ruling on my motions. So then it got worse. They had me come in October of 2008. I'm sorry, November of 2008 for a pretrial hearing conference. Now, when a prosecutor calls for a conference, you have to go. You got to go, or there's a warrant issued for your arrest. This was not a Rule 8 or Rule 12 conference. It was just they want to have a pretrial conference. So you go in. I drove in, and the prosecutor says, okay, do you want to take a plea? I said, no, I didn't do anything wrong. Let's go to trial. They said, okay, thank you. Go home. So I do 1,500 miles for a 5-minute conversation. They did this again in December, and you have to come in. So you drive 1,500 miles. Say, will you take a plea? I said, no. 5 minutes, 1,500 miles. Again in January. How, you want to take a plea? No. Drive home. It's getting dangerous because when you go from Vermont to Ohio, you have to go over the Adirondacks, and it's really, I hit a deer, and I had an accident during one of them. And so anyway, they say, okay, we're going to trial on March 2008. I'm like, okay, I'll be there. So I called the WKYC and I said, this is happening. Are you guys interested? And they go, yeah, we're real interested. So I show up in the morning, drive all night, and I show up for trial. And I think it was March 3rd, 2008. And there's a guy with a camera there. They're setting up. So I go in to the courtroom because I'm ready for trial. My case wasn't called. I just sat there from 8:30 till 4:30. No one said hello to me. It was Judge Michael Russo's courtroom. Michael Russo's dead now. His bailiff, Pat Smith, didn't speak to me. I just sat there all day. They ignored me, disregarded me. And finally, security came and he said, we're closing the building now. You got to go home. I said, what about my trial? And he goes, I don't know anything about that. So I went into the prosecutor's office and I said, what's going on? And they said, we're not allowed to talk about it. So that's like trip 4 or 5, no trial. So they call me back in April for, another one of these conferences. Will you take a plea? I say no. They call me back in May and drive again. Will you take a plea? No. This time I got the public defender, a guy named Bob Tobik, on the case. And Bob said, okay, we're going to negotiate. So they have trial set for June of 2008. So I drive in again for like the 7th time. I drive in. They say, will you take a plea? I said, no. Trial's canceled. So, and the judge still hasn't ruled on any of my motions or my alibi defenses. The fact that I didn't do anything wrong. that I got a no bill, and that the statute under which they were indicting me only applied to changes in an original court document or people who have altered a will. I mean, I wrote on a copy in green ink and told the FBI that, okay, they forgot the subsection in the copy, but it doesn't matter because it's a misdemeanor. Like, it doesn't matter. It's comical. So, and the FBI agreed. They said, okay, yeah, it doesn't matter. Here, go get your gun. You're not a felon. It's not fraud. So they canceled. So they, I had needed abdominal surgery in July. So then in August, they have another pretrial hearing. They said, do we take a plea? And I said, no. I could drive back to Vermont. And, September, they do it again. I drive in. This is like, 8 or 9 trips. So finally in October, they set another trial. And so I drive in. And the Bob Tovic, the public defender, said, listen, Bob, they're not going to give you a trial. And they're going to keep doing this because this is what they do. They said most people who are indicted come in, they call you in for these little pretrial conferences, and they ask you to take a plea. And if you don't, they send you home. Most people lose their job after 5 of these. And they succumb, they submit to taking a plea. So by this time, anyone, they wear you out. You've lost your job. You have no confidence in the legal system. So the prosecutor gets what he wants, even if he's just, over indicting. So they said, Bob, here's what they'll do. You take a $50, you plead to a misdemeanor, some lie, and a $50 fine, $50 fine. And this thing will end, because otherwise it's not going to end any other way. You're just going to keep coming here. So I had to do it. I mean, I just couldn't do this anymore. It's like 11 trips. I didn't trust the system. The judge wasn't ruling any of my motions. I see the whole thing is a lie. And I don't even know if I can go to court anymore because I've been declared a vexatious litigator. So I took the plea. It's very bad. Now, here's what happened during this time. This is, I took the plea in October of 2008. During this time, everybody involved in the case either resigned or fired or went to jail. The prosecutor, Bill Mason, who was, pursuing this, was forced to resign. The person about whom I wrote the editorial, Peter Junkin, disappeared from office. And the FBI was chasing him. The criminal clerk of courts, a guy named Mark Lime, turns out had been falsifying my docket. The docket is a court record. And every time I'd come in for, now, courts in a criminal hearing, you have a right to a speedy trial. You have the right within 90 days to have a trial. Now, that right can be changed if a defendant, in writing, makes a motion for a continuance. He says, listen, I'm not ready for trial. I waive my speedy trial rights and just give me a little more time. But I never made any motions for an extension of time, and I never waived my right to a speedy trial. The criminal clerk of courts, Mark Lime, who went to jail for a very long time on 76 counts of docket falsification, was saying in my record that I kept asking for continuances. I never did. There's nothing in writing. I never signed anything. And I asked the public defender about this, and he goes, oh, yeah, they always do that. They have the default setting. When the prosecutor asks for a continuance or wants more time, they charge it to the defendant. And I said, well, what about the rule that says it have to have, a request, a motion signed? He goes, that doesn't matter. They just falsify the docket. So Mark Lime, the criminal clerk of courts, the chief criminal clerk, went to jail for several years. And Joe O'Malley, who was chasing me on, participating in this, the prosecutor from Bedford, was also put in federal prison. So I was confirmed. I guess I was sort of lucky that they were, in a defensive position. But everything I'm saying was confirmed in my book. And everybody in Bedford Municipal Court eventually, the judges and prosecutors were put in jail or resigned. So then it gets worse. If you can imagine, it gets worse. It turns out I was a member of the Washington State Bar. So while they're bringing false charges against me, they sent an anonymous letter to the Washington State Bar saying, by the way, Bob's, committed a felony. I called the bar and said, listen, this is a lie. I didn't commit a felony. I didn't do anything wrong. As a matter of fact, you should give me a medal for exercising my First Amendment rights and obeying my obligation to defend the Constitution. I'm exposing corruption by myself, which no one ever does. All attorneys are pledged to defend the Constitution, but they're mainly committed to their income. And one attorney, from Washington said, Bob, you're really brave. You don't know it, but no one would do what you're doing, and it's necessary. So I'm doing it. So anyway, they called the bar, and I called the bar and said, listen, this is very serious business. Just stay in touch with me because I have a good story, and I'll answer any questions you want. So anyway, about 3 years later, I hear from the Washington State Bar that I reported an attorney in Washington State. I had a litigation there, and the attorney was stealing from my mother, who was living in Washington State at the time. She moved from Cleveland to Washington State. And the trustee was stealing from my mother, and the attorney was taking money. The person who was stealing from my mother's estate was paying himself out of my mother's estate to defend the person who was stealing from my mom. So I reported him to the bar. You can't do that. If a person's stealing, the trustee is stealing from my mother, the person who's stealing should pay for his own lawyer. My mom shouldn't be paying for the person's legal fees who's stealing from her. It's like comical. So I get a letter from the bar saying they're going to prosecute me for what happened in 2007. So I said, well, why now? It's a little late. You guys have a statute of limitations. They said, we're doing it anyway. So I make a motion I file in federal court to stop the proceedings because I was in Vermont. They couldn't serve me and I wasn't a resident, but they have the hearing anyway. So I fly in, present all my evidence. The hearing officer listened and said, okay, I find that, Bob did nothing wrong in Ohio or Vermont or anywhere. Okay, that's good. Then they disbarred me anyway. Wait, the hearing officer said I didn't do anything wrong. You just make enemies. So the point of all this business is that I thought that the legal system is a set of rules that people follow. They don't. It's a set of personal relations and professional relations. And the idea is to maintain your group at the expense of things you're pledged to protect, which is the rules and the laws and the social contract and the things that keep us together as a people are secondary to these people doing personal favors and saying, okay, my income group needs this. And we can do it at the expense of someone who doesn't matter, because a person alone is a dead person. So I, made an appeal to the Washington Supreme Court, and they refused to hear the case. They refused to hear my appeal, for the bar hearing. So the legal system is very uncertain, and it's uncertain on a national basis. So it's like this everywhere. We're a nation in decline. So just two more things. I realize this is a lot, but I went to to protest my to protest the determination of my criminal case in Cleveland, to say I didn't get due process. They violated my right to speedy trial. I got a no bill. I didn't get due process. They wouldn't give me a trial. I went to federal court, and I got Donald Nugent. He's still there. And Donald Nugent, saw that I was, holding his friends accountable, and immediately told me I'm never allowed to file in federal court again. They imposed, filing restrictions on me again. And under the All Writs Act. Now, under the All Writs Act, You can't ban someone from a court without charges and a hearing. But he didn't care. He just banned me from federal court and protecting his friends in the state. And there was no due process, no defect, no nothing. That's what they do. They say, you government and organized crime aren't that different. You threaten my group. We injure you. We ruin you. I mean, I put myself through law school and most of undergraduate school, worked very hard, did the right thing. And Washington State disbars me because I, exposed them in federal court. Donald Nugent, who's still there in federal court, bans me, make sure I have no voice in federal court. Now, there's one other thing I'll tell you about. I realize this is a lot. I hope I'm not talking too much. In 2017, I said, okay, everyone's been arrested and cleared out. The judge who declared me vexatious in 2005, Lillian Green's gone. The person who took over her docket is in jail on murder. Remember the judge who went to jail on murder? Really?
No, I'm listening.
Really? I'm trying to remember his name. He went to the University of Michigan. He was found to have murdered his wife in Shaker Heights. At first,
Oh yeah, I remember there was a black guy. Yeah.
Right. He was very, very pleasant. He went to Michigan, very well liked. At first, he broke her, orbital, and then he got another. He wasn't a judge anymore. Then he murdered her. He took over Lillian Green's docket. He was gone. So in 2017, I made a motion to have my vexatious status removed. I got Judge John Russo. So he has me drive in from Cleveland, and I'm driving from Vermont. Lance Mason's the name of the judge. Lance Mason, judge who murdered his wife. So anyway, John Russo, who's still a judge there in Common Pleas in Cuyahoga County, has me drive in, and we have a hearing, and he says, here's what I'll do. I was sitting for the bar in another state. He goes, if you pass the bar, what I'll do is I'll remove the vexatious litigator status. So I said, well, Your Honor, I need this to get into the bar. I'm going to pass the exam, but I needed to get past character and fitness. So, knowing that I have not passed the bar, knowing that I'm not an attorney anywhere else yet, can you please just remove the filing restrictions? I made a motion for alternative ruling. So he was very nice, and he goes, okay, I'll do that. And it's in writing. He said, based on, Bob's motion for alternative ruling, knowing that he's not, an attorney anywhere, I removed Bob's vexatious litigator statute. It was all a mistake in the first place, and he's no longer vexatious. Great. Wonderful. Someone did something nice for me in Cuyahoga County. I couldn't believe it. So 2 years later, I sent a bunch of copies of my books to judges in Common Pleas. I figured, they might like to hear it. There's some judges there who will remain nameless who are sympathetic to me. So I sent a bunch of copies of my book to a lot of judges. Next thing, I get a call from John Russo's staff attorney, someone named Caitlin Carlin. I said, well, Judge Russo wants you to come in. I said, why? There's no jurisdiction. There's no complaints against me, civil or administrative or criminal. He has no jurisdiction. You just don't call someone and have him come in. And he goes, yeah, well, he wants you to come in. It's about, I said, what? About what? Can I know charges, due process, a statute, a charge, so I can have a defense? He goes, no, he just wanted to discuss, some of the stuff that happened in 2017. So I learned the hard way. When a judge says, come in, go in, even if he has no jurisdiction. You don't have an active case. You've done nothing wrong. Civil, administrative, or criminal charges. So I go in there, show up, and he starts shouting at me. He goes, I'm reimposing vexatious status on you. I go, why? He goes, because you lied to me. You said you were an attorney. I said, no, Your Honor, I didn't. I told you, and it's in writing, that I made an alternative motion saying, I cannot become an attorney until this is off me. And we had a hearing about it, and it's on the record. So anyway, he reimposed without any due process, without any charges, without, the Ohio Vexatious Litigator Statute, ORC 2323.52, requires a new hearing, charges, a complaint, service, motion practice, a trial. He says, you're vexatious again. And he says, I'm the liar. He says, I lied to him, but I didn't. They're the lie. Everybody lies. Everybody cheats. And if you're not a liar in the legal system, you're not part of the group. I'm done. Thank you.